folks, we're back. This is Steve Sampson and Stephanie Phillips with another episode of Veterans in Politics, and today we have Michael Gibbons, Nevada Appellate Court Judge. Just to let you folks know that we are sound and camera engineer is not here, so if the show sounds a little bit foggy, it's not us, okay? And this is a special show that we're doing on a Tuesday instead of a Wednesday. But before we get to Michael Gibbons, Ms. Phillips.
Thanks for joining us, everybody, and thanks to our sponsors. We have Dr. Ari Nagy. He's running for Congressional District 3. His website is nagyforcongress.com, and that's F-O-R, nagyforcongress.com. Jump on his website and check out his platform. Also, we have Michelle Romero. She is Henderson's mayor, and she's running for re-election. Her website is votemichelleromero.com. votemichelleromero.com. Get on her website and get in touch with her. And also we have Cody K. Whipple. He's running for Congressional District 4. His website is codykforcongress.com, and that's the number 4, codykforcongress.com. Get on his platform and see what he is all about. Also, don't forget our block party is this Friday. It is the 24th. It's from 5 to 10 p.m. We have flyers all over our Facebook. It's on Whispering Sands in between Sisk and Torrey Pines. And there's going to be all kinds of fun stuff for the kids, so bring the whole family. And we're going to have a really good time. Wear your costumes if you want. We're going to have costume contests. Also, don't forget to get your tickets to our Valentine's Ball. It's February 7th of 2026. We have early bird tickets on sale and also on our Facebook pages. The link to the tickets is there. Don't forget to get your copy of Steve's book, How to Navigate Nevada's Family Court System. You can get a copy on Amazon. It is $14.99. And for all those family court litigants who don't have an attorney or can't afford one, this is a self-help book, and this will help you navigate that system. So be sure and pick up a copy of this. Also, we have a merch store. It's VIPImerch.com, VIPImerch.com. There's all kinds of fun stuff on there for you to check out. And I do have a rant, but I'm going to wait till tomorrow night because we're going to family court tomorrow, and this is going to be on family court judges. So Steve has our rant for tonight.
Well, for time reasons, I was going to skip the rant since we're 9 minutes into the show. Well, 9 minutes late, so I'm going to skip the rant.
Okay.
And I'm just going to go right to Judge Gibbons. Thank you for coming on.
Thank you for inviting me.
Absolutely. Could you give us a background, please?
Okay.
A bio.
My name is Michael Gibbons. I'm a judge on the Nevada Court of Appeals. I've been in this position since the court was formed in 2015. Prior to that, I was a district court judge in the 9th Judicial District, which is Douglas County, Nevada, which is just south of Carson City. It also includes the South Shore of Lake Tahoe. Before that, I was in the district attorney's office in Douglas County for over 13 years. Almost all that time was as a criminal prosecutor. I prosecuted hundreds of cases, every type of case. And I started my career in Nevada as a law clerk for District Judge Howard McKibben. That was in 1980, also in Minden. And I was very fortunate to have started with such a fantastic judge. And we'll talk a little bit about that more in the future in this interview tonight. But before that, I'm from Southern California originally, grew up in Whittier. I went to Cypress College and then transferred to UCLA, and I graduated from there with a degree in communication studies with an emphasis on mass media. I thought about going into broadcasting myself. I had long planned to go to law school, but I considered broadcasting. Once I was there, I was a disc jockey on the school radio station.
Where are you now?
I had a lot of fun with that.
That sounds fun.
Yeah,
and now look at you.
And then I could have gone to law school in LA, and I decided to leave and try something different. And I went to University of Idaho in northern Idaho in Moscow, which is right on the border with Washington State and Pullman, Washington. I worked in a law firm there for 15 months while I was in law school. And I came to Nevada right out of law school. But one interesting fact about my law school graduation, I was the chair of the law school graduation committee, which isn't the interesting fact. The interesting fact is what happened the next morning. My parents came up to be there for the graduation. This was May 17th, 1980. And the next morning I was taking them to the airport in Spokane, Washington, and Mount St. Helens erupted.
Oh boy.
And I didn't know it had erupted. I didn't find out till I dropped them off at the airport, and the sky turned black. And I'd been listening to music, and I turned that off, turned the radio on, and the first thing I heard the radio announcer say was, "We're all in this together." And I thought, whoa, what is happening? And then the ash started coming down. So, long story, but I was stuck in northern Idaho for a couple weeks, and then moved to Las Vegas to take the bar exam, the review course, then the bar exam. So that's a bio in a nutshell about my professional career.
Sounds very interesting. So let's get right to it, Judge Gibbons. In 2014, the Appellate Court was created, and you're one of the original Appellate Court judges. How does that make you feel?
Yeah, it feels pretty good, actually. Can I give you just a little bit of history on how this court got created?
Sure.
And then we'll go to where I fit into it. Nevada has long wanted an appellate court. Almost all states in this country, about 40 out of 50 states, had an appellate court. We only had a Supreme Court, and Nevada is a very fast-growing state. And because of that, there's more litigation, more court cases, and the Supreme Court got overloaded with cases. So the Supreme Court came up with various methods to try and get quicker dispositions, and it was helping, but it wasn't enough. So there were several attempts to get a Court of Appeals created, but it took a constitutional amendment to do it, and it didn't pass until the fifth try. The fourth try was in 2010. The fifth try was on the ballot in 2014, and in between that time period, the legislature had to approve it twice. So that's how you get a constitutional amendment in Nevada. It can be approved by the legislature twice and the voters once, or by the voters twice. So this was the former method. So that was the quickest way to get it on the ballot, and it passed in 2014 with 53% of the vote. And the Supreme Court announced the very next day that it would be accepting applications for judges for that court for the next week. So I had a week to put together an application. Now, I'd already been thinking about it, so it wasn't a total surprise, but the form is extremely detailed about it, and there were 36 applicants.
Wow.
So to make it to one of the final it was the final 9. There were 3 open seats created by this, and so there were 3 applicants selected by the commission on judicial selection out of the 36 for each seat. So 9 applicants, and then the governor would pick 1 out of 3 out of each of those 3 seats. So Brian Sandoval was the governor at that time, and I had an interview with him, and it went very well, and I was selected. So I mean, I felt
Congrats.
I felt totally elated. I knew I had tough competition, and you never know what's going to happen. And I originally was a judge by winning an election, and I had to go through an election to retain my seat. So to go through the selection process and not an election was a big change. I'm used to the election process. So how did I feel? I felt great, and I was appointed the chief judge right at the outset, and so I had extra responsibility for that, and to try to get a new court going. Now, as you know, and not all the viewers or listeners know, my brother was already on the Supreme Court at that time, so I had a little bit of help.
Mark.
Yes. Mark Gibbons. So anyway, that's another story. But I did have plenty of help that most other people would not have had.
So could you explain exactly the purpose of the appellate court and what your function in the appellate court? Because it's supposed to be just for oral, it's not supposed to be for oral arguments, right? It's supposed to be just for motions and briefs and stuff of that nature, and then you guys render a decision.
So I'm sure many people have heard the phrase "justice delayed is justice denied."
Right.
That actually goes back to the 19th century, and that was the idea in Nevada. If your case took years to get resolved on appeal, you were waiting, and no matter what side you were on, it was a very difficult situation, stressful and expensive. And so the idea was to speed up the resolution of cases. And as I mentioned earlier, the Supreme Court came up with various techniques, but there still was a significant backlog. So within the constitutional amendment was a procedure that said the Supreme Court could set the jurisdiction of the appellate court. So a rule was created that decided what cases would go to the appellate court. And so it's that rule's been changed a couple times, but the idea of the rule is the Supreme Court would keep the most serious cases, and the less serious cases would go to the appellate court, plus areas for specialization like family law and administrative law. So that's how the cases are come to our court. It's from the Supreme Court. It's not a direct appeal to our court. All appeals go to the Supreme Court, and the Supreme Court sends approximately 1/3 of its cases to the appellate court. So that means, roughly 750 cases a year get sent to us, and it's up to our discretion whether we will have oral argument on a case. So there are not that many oral arguments. I know you were present at our last one of our last arguments, but we've been doing oral arguments since 2015, and I can still remember the first one very clearly, and the second one that same day. And we used to be in the Regional Justice Center here in Las Vegas. So I won't go on unless you ask me about that, but that was the basic idea. I know you have a lot of questions.
Ms. Phillips?
We hear if you could explain this to the viewers, we hear reverse, remand, dissent, affirm. We hear all of these terms. Can you explain what those mean and what that is?
Yeah. Well, if a case is resolved in the district court, then a party can appeal, any party can appeal to the Supreme Court, and as I mentioned, the Supreme Court will assign roughly 1/3 of those cases to our court. Once we get the case, we have full authority to decide whatever we think the law requires under the circumstances. The options are to affirm in total, affirm in part, and reverse in part, and reverse, and there's a couple of variations on it. But the basic idea is whatever was decided in the district court, be it by a judge or a jury, a judgment is entered, and we're looking at this judgment, and is the judgment correct under the law? And we hear, of course, all the arguments of people that are appealing, and if we affirm, that means things stay exactly as they happened in the district court. If we reverse, that means it could change completely, or it could be a reverse and remand where we send it back to the district court with instructions to follow a certain area of the law that wasn't done correctly when it originally was in the district court. So those are the basic options: affirm or reverse and remand.
So you could affirm part of the decision and reverse part of it, but it still goes against them as a reversal. It still counts against those numbers, right?
It depends who's doing the counting.
Okay.
I mean, it really shouldn't, because a lot of times the reversal is on a very small point. I mean, parties can raise numerous issues in a case. Let's say you raise 10 issues and there was an affirmance on 9 of the 10, a reversal on 1. There was a case that came out last week from the Supreme Court where that was the very situation. It was originally a case in our court, and the Supreme Court took it up. And so would you call that an affirmance? When one conviction was reversed, but the other 19 were affirmed?
Mm-hmm.
So.
Do you see mostly family court cases? I know the one we sat in was on a divorce on the marital property, I believe.
Right. Oh, that's right. You were
Which
there
was,
too.
Yeah, that
Yes.
was very that was interesting because that was difficult actually. They both had good points, but sometimes when I hear these decisions and read what you guys what you come down with, it seems like, and tell me if I'm wrong, but it seems like you try and back up the judge as much as you can in what they did and them applying the law and all of that, but also it seems like you try and play both sides, and I don't mean to minimize it or say it that way, but sometimes the judge gets some and the plaintiff gets somebody that's appealing. So how does that
Well,
How does that work?
Well, the first part of your question was what type of cases do we do, and then you mentioned family law, and of course, family law is a big part of it. So back to the 2/3, 1/3 split. The Supreme Court keeps about 2/3 of the cases. They have 7 justices, and they have a bigger staff than we do. They automatically keep death penalty cases, certain very serious crimes, water law, tax law, election cases. The Supreme Court keeps those cases under the rule. We have no chance of getting them. There are a whole set of other cases that are called presumptive cases. They probably go to the Court of Appeals, but it's not automatic. So family law is in that presumptive category. If it's a family law case, the Chief Justice is going to look at it and say, this will probably go to the Court of Appeals unless there's a particular issue the Supreme Court needs to address, like a new law or something. We also do, actually most of our cases, more than 50% are criminal cases. And we do, I mentioned administrative law, workers' compensation is a very common area of administrative law, and then civil cases, jury trials of all sorts, slip and falls, rear-end accidents, all types of different tort cases, contract cases. So we have quite a variety. Back to the family law case that you were talking about, we did issue a decision on that case, and you're kind of right on that and how you phrased it, because there really were 2 sides on that, and we affirmed in part and reversed in part, but they were different issues. So on some of the issues, the district court, we said, had enough evidence, followed the law, and got to its decision is affirmed. We reversed on one small issue, and that was the court had ordered the husband and wife's home to be sold, and all of the proceeds from the sale were used to pay off debt, and they'd split the difference. However, the wife, who's also mother, wanted to retain the home and have children there. They were with her part-time. It was split custody. But she said, I can't afford to get a new home. I can't even afford to rent. And if the house has to be sold, then I don't know what I'm going to do, because I won't have anything. And the monthly payment was such that she could keep the home. So, but the husband had to be paid off his share. So what do? So we sent it back to the judge to say to look at this again. The judge didn't give it as much consideration as should have been done. And so he said, see if there's a way that this can be worked out. Maybe it can and maybe it can't, but look at all of the circumstances and see if there's a way to keep her in the home, at the same time pay off the husband his share. And you know how he would have been paid off? He was ordered to pay her alimony. She could forego that alimony and keep the home as a possibility. So that's a question of fairness in a situation like that. Maybe it would work for both of them.
But how does that work when you send it back to the same judge that believes that their decision was right to begin with, and you say, okay, judge, you need to look at this again because you're wrong and make it right, and some judges don't want to do that. How do you handle that? How does that even work?
Well, it's
because they feel like they're losing face.
Right. Well,
Yeah, don't they have to do what you said? I mean, that it went through your court for a reason.
Right.
So don't they have to adhere to what your recommendations are?
Well, the formal term is stare decisis. It's precedent. Once there's precedent, all their lower courts have to follow it. In this situation, it was not a published opinion. It was an unpublished order, so it's only law of the case. That's the legal term. So since it's the law of the case, that means that lower court must follow it. There's no choice. They have to do it. Here, it's not
And
like...
if they don't?
Well, they could get in trouble. I mean, there's a...
Who's going to get them in trouble?
Well,
who's going to turn them in?
there was...
The
there is
Nevada
a...
judicial discipline.
I don't
Who's going to write to them?
I don't want to get into this other case, but that very issue just happened with the judge here in the recent past, and she was suspended for not following what the Supreme Court said, according to the Judicial Discipline Commission. So that can happen, but I mean, that's extremely rare. Judges are happy to follow. A lot of times they're just not sure what the law is. And in this case, it's hard to really blame the judge, the example I'm telling you about, because the wife didn't have an attorney. She was representing herself. The other side had an attorney, so she was at disadvantaged in that circumstance and didn't present her case nearly as well as could have been had there been an attorney there representing her. So the judge only had so much he could work with. I mean, there were some missing pieces of evidence, and that's what it was. But we thought that this issue was not fully developed, and the court should take another look at it on remand, maybe have new evidence, but the judge can still do what the judge feels is appropriate after he considers the new evidence.
So they don't have to follow what the appellate court says?
No, they do, but we don't tell them what the result is. When if it's a straight reversal, we tell them the result. This is a reversal and a remand for further hearings on it to find out what the facts are about keeping the house, and could there possibly be an exchange of alimony for the home. I mean, that's totally up to the judge after he considers all the evidence and hears the argument. We just said it wasn't developed enough. It needs to be developed more because of the consequences were severe, where she wouldn't be able to get a home.
So if the lower court does not listen to the appellate court, what is the litigant's
remedy?
Recourse.
Yeah, recourse.
Yeah.
Right. Well, they have the hearing again, and if they don't like the result, they can ask for reconsideration in front of the same judge. And if they don't like the result, they can appeal it again. And once in a while that happens, but it's pretty rare. I mean, judges follow what they're supposed to do. It's extremely unusual to see them not implement it. Maybe there's a question of what is the law in this situation. It's not always clear, but the judges I think they're trying to follow, and we just don't see people that are ignoring our decision. That doesn't happen.
So so in the appellate court, when you rule on a particular case, do you use your discretion, or do you follow the law as it's written?
Okay. Well, there's what's called the standard of review, and discretion is one of them. I don't want to get too technical on this, but abuse of discretion is the usual standard in a family law case, for example, meaning did the judge that heard the trial abuse his or her discretion? And it's a very deferential standard. If they have almost any evidence to support it, they did not abuse their discretion, as long as they followed the basic law on it. There's another type called de novo review, meaning we look at it anew, we look at it fresh,
Right.
And that's typically an interpretation of what does the statute mean, what does the Constitution mean, and we're not just coming up with this stuff on our own. We have to follow our own procedures. I mean,
Right.
we don't make this up as we go. We're following existing law too. So we can get into that a little bit more if you like.
How often do you see, because family court, I mean, we go down to family court, pretty often, and we follow some cases and advocate for litigants, so that is of extreme interest to us, and some of the decisions and things that we see from these judges is amazing sometimes. But how often do you see where a judge just completely messed up the entire case, where you just were wondering where were their brains? What were they thinking on this decision? How often do you guys have that kind of a case, an appeal?
Rarely. I mean, we don't see that. I mean, typically the mistakes we say they make are smaller in nature. They mess up everything. They can mess up parts, but they generally follow. But remember, I mentioned a party can ask for reconsideration while it's still in the district court. It gives the judge a chance to fix errors before it ever goes to an appeal. So that's a very good mechanism to sort of solve these problems. And of course, something that I've seen is that you can read a small part about what happened or see a small part and it looks bad, but when you look at everything that happened, it sometimes comes together and you understand why that other part went the way that it did. So we have to look at it as a whole. We don't just look at one isolated incident.
So that's why some of those decisions, when I said earlier that it looks like, you try and find, as much as you can that the judge did right, but then you've got, maybe one or two issues over here that you reverse. Because it seems like there's a balance there that it's, give and take on those cases.
Well, do you know what a really good example of that is in a custody case? the best interest factors, because the court is supposed to award custody based upon the best interest of the child. And it has a statute, we have a statute with 12 factors in it, and the judge applies the relevant factors. Well, what if 4 of the factors were right and 1 of the factors was wrong? Do we then overturn the decision? Well, a party on appeal has to show us that that error made the difference in the case. In other words, it was a harmful error, prejudicial error, and not just that there was an error. Everybody is entitled to a fair trial, but there's no requirement for a perfect trial. So we have to see if it affected the actual result of the case, and the burden is on the person appealing to show us why that is true.
So what does your caseload look like annually?
So I mentioned the number 750 earlier.
750?
Yeah, we're around that. Looks like we're going to hit about that number this year. And it's that, again, that whole variety of cases that I mentioned earlier. And that's 3 judges, but we also have law clerks and staff attorneys that help us, because some of these cases have gigantic records, and other cases are from inmates in the prison represent themselves, and they write handwritten appeals, and somebody has to interpret those occasionally, or the copying's not good on them, and those can present some challenges. So we have other people that help us go through that and have a particular expertise in these types of cases.
So there's 3 of you. Have you ever been the tiebreaker?
Well, we actually have had a couple cases that were 1-1-1. And so the question is, if you have a split 3 ways, where do any of those overlap with each other?
So what do you mean? One says remand, the other one says affirm, and the other one says what? What's the other one say?
A combination.
Well, no, I mean, that's at the end of the case. So let's say a case has 3 different issues on it,
okay.
and each judge had a different view on each issue. So you end up then, if you agree on 2 issues, but you don't agree on a third, and it's a 2-to-1. I mean, that can happen. I mean, it's very rare, but it has happened. And so the part that where 2 judges agree, that becomes the law of the case, whether it's affirm or reverse. And
any improvements you think that should be made in the Court of Appeals?
Well, we're looking for improvements every day, and we had our monthly court conference today, and at the end of our conference we went through some of our changes we've made recently to see how effective they are. We called in other people on our staff to get their view on it, and we're always looking for ways to improve, because our mantra is really simple. We want to have speedy resolution of cases, we want to be accurate in our decisions, and we want to be fair in our results. And we're trying to meet those goals every day, and there are always ways you can improve things. So that's what we do. I mean, we are really fast on getting our results out, particularly in family law cases. We have an internal rule of resolving child custody cases within 90 days of them being received by our court. Sometimes that's not possible for various reasons, like oral argument will extend the time. But as a general rule, we don't have to do that, but we do it because they're really important for kids to get finality on where they're going to live.
We were talking earlier and wondering about this, and when we were talking about tiebreaker, do you guys go and go through the cases and make your own decision and then come back out and say this is the way I would rule, or do you guys all kind of get together and talk about the case and have a collective? How does that work when you guys are looking over a case?
Well, it's actually both. We use both those methods. But just to back up for a second, when I was a district court judge, think about this. I'm one judge making the decisions on thousands of cases. And all I have is one law clerk to help me research it and come to the result, and sometimes they have to be done quickly. And so that is an extreme challenge. In our court, we have 3 judges, so everything is a group decision. But we have time to put it together because we don't have people sitting there in court waiting for their decision. So we, as I mentioned, child custody cases, we have 90 days. So a case is assigned to a particular judge, and that judge works it up and makes a recommendation to the other judges about this is what the law is, this is what the facts show, so this is what the result probably should be. We have other people review it, and then to see what they think from our staff, and then the judges meet and we make the decision on it. So like we did that today in our court conference, the cases we went over. So everything ultimately is a decision either in person at a conference or by email, because we have so many cases we can't sit down and literally talk about all 750. We do some of them by email.
Yeah.
So, but every single case, the judge weighs in on. Each judge.
So you were a district court judge for Douglas County, right?
Yes.
And your brother was a Supreme Court justice, and now you're an appellate court judge. Could you explain the three different levels of our judiciary?
Okay. Well, we actually have 5. You want me to do all 5? Because we start with the lower courts.
Or you want to go with the muni and the just?
Right.
Okay, might as well.
So I'll try and be really quick. So Nevada is divided up in different jurisdictions. That's simply a legal word meaning what is the scope of area where your cases are. A municipal court hears cases from the city. So Las Vegas City has a municipal court. If an event occurs within city boundaries and it's of a certain type of event, it would be filed in the municipal court, criminal or civil. Justice courts are county courts, but there are townships. And the county can set up as many townships as it wants. So here we have Las Vegas Township, Henderson Township. There's a number of outlying areas of Clark County that have townships. So there are like 5 or 6 different townships. Might even be more than that. Then there's the district court. Well, back on the justice court. The justice court will also hear not only the small criminal offenses, but felony offenses at their initial stages. So the justice court judge sets bail, has preliminary hearings, that sort of things. If there's enough evidence to hold the case for trial, then the justice court sends it to the district court. The district courts there are 11 districts in Nevada. And Clark County is the 8th judicial district, which is just Clark County. I was in the 9th judicial district, which is just Douglas County. But the 11th judicial district is 3 different counties in northern Nevada. So it just depends on the area. So a case is heard in district court if it's more than $15,000 at issue in a civil case, if it's a family law case, or if it's a felony or gross misdemeanor criminal case. After it's done in that court with a jury verdict, a judge verdict, a plea agreement, a settlement, however the case was resolved, as I mentioned earlier, it can be appealed to the Supreme Court, and then if the Supreme Court determines it's appropriate, it sends it to the Court of Appeals. So you have muni court and justice court, the lowest level, then district court, 11 districts, then the Court of Appeals. Our jurisdiction is the entire state of Nevada, and then the Supreme Court, the entire state of Nevada. So we have cases from all 17 counties.
So when are you running for Supreme Court?
No, I am not planning on running for Supreme Court. When my brother retired at the end of 2020, I gave it consideration, but I decided I was happy where I was, and we were still developing as the Court of Appeals. And I had the institutional knowledge to stay with the court. We had already lost Judge Silver. She'd been elected to the Supreme Court, so she was gone. But at any rate, my brother served 6 years on the district court here in Clark County, and his last year was the chief judge, and then he was elected to the Supreme Court in 2002. And how do you like this? Nobody ran against him when he ran for Supreme Court in 2002, and then 6 years later, somebody did run against him. So he ended up serving 3 terms or 18 years on the Supreme Court.
So what do you tell the public? I mean, how do you gain public trust when the public thinks that the courts favors insiders, the court favors the judge and not the litigant? I mean, how do you build public confidence?
Well, courts in this country, it's extremely important in a democracy or a republic to have courts that instill confidence, because we're a separate branch of government, and we have 3 branches for a reason: the executive and the legislative. In some countries where courts don't have the confidence of the public, people resort to other means to resolve their disputes. We have to have faith and trust in the court system so people will accept the judgments as accurate, and having appeals is one way to do that. But transparency and openness at every step is extremely important in my view. That's one way so people will know exactly what's happening and have proceedings that can be recorded or video presented, like our oral arguments are presented on YouTube, so anybody can watch them. So anything to open the courts, I agree with. Now, that's not absolute. There are some exceptions, but as a general principle, you should always start with open courts and have outreach wherever you can. I used to have various groups that would come through the courts, and I'd spend some time and give them an explanation of it. We have tours at the Supreme Court, both in Carson City and Las Vegas. So, reaching out to the public is important. I mean, there's other things we're going to talk about, I'm sure, but that's sort of an overview.
So you served on the Nevada Commission of Judicial Ethics, right?
I served as there's two different commissions. I served on the Judicial Discipline Commission for 1 year as an alternate commissioner, and I served on the Judicial Ethics and Campaign Practices Committee for 8 years. Now, did you hear the last couple of words I said? Campaign practices? Mm-hmm. That used to be in the title, but that was later ruled unconstitutional, so that was taken out. That control over campaigns is very limited because of the First Amendment and free speech, but the judicial ethics part of it is still going.
Do you feel that they have good oversight, that they really look into things and square things away? How do you feel that those...
Who do you mean by they?
Do you feel a judicial commission on ethics, do you feel that that particular organization does the people's bidding, so to speak? Do you think they look into cases? Because I have filed...
You're talking about judicial discipline and not judicial ethics. Two different things.
The ethics.
Ethics is not... They don't investigate anything. The ethics,
they don't?
No, wait, remember, hold on a second. The ethics committee just gives opinions on questions about ethics. So a judge can submit a question, can I do this, can I do that? The Judicial Discipline Commission investigates breaches of ethics. So two different things.
So what happens if the public files something with the Ethics Commission? They only going to give an opinion? They don't do anything else?
So well, I don't think the public files with the ethics. They file with judicial discipline.
I filed with the
judicial discipline.
Both.
Both?
Yes.
Maybe that's why you didn't hear about it. They don't answer the public. You're in the wrong jurisdiction.
I filed with both.
All right. Well, I finished my 8 years a long time ago on the judicial ethics, so I don't know what the current procedure is. But as far as I know, it's just responding to judges. Judicial discipline responds to the public. And incidentally, when I was applying for the Court of Appeals, I mentioned the long application, and we also had to sign release forms like taxes and credit reports, but also the Judicial Discipline Commission, because they're confidential. And so we had to sign a release that said any complaints that have ever been made against you can be given by the Judicial Discipline Commission to the Judicial Selection Commission, so they know people who suffered complaints.
Right.
So I got this letter in the email, a letter from the Judicial Discipline saying, well, we've turned over your records to the Judicial Discipline. So it's like, uh-oh, that sounds pretty scary. And so as it turns out, in my 20-year career, I had 9 complaints, and a number of them were from the same person on one family law case.
Oh, wow.
And of course, I didn't even know about them, because if the court determines that they don't have if the Discipline Commission determines it does not have jurisdiction, or there's no basis for a complaint, they don't even tell the judge. So anyway, that was it. So I was pretty relieved, because it's kind of scary. You had an inquiry from this. I thought that's what the letter was, and then it wasn't.
So do you have many pro se litigants from family court that are appealing to the appellate court for reversal of a judge's decision?
Many.
And how many of those are fathers and how many are mothers? Do you know?
I don't actually know that.
Is the fathers more or the mothers more, or vice versa?
We have a lot of stats, but I'm unaware of that stat. And I can't even think about it anecdotally if it's more or less. I mean, it's both sides. There's plenty on both sides. So that case, that you saw, it was It was the mother was appealing, and wife, she didn't appeal the custody decision, she appealed other things. But we get lots from fathers, lots from mothers. It goes both ways.
But she had an attorney with her when she was before you guys.
Yeah, but that was a pro bono volunteer attorney.
Oh, okay.
So you work out of Carson City, and how often do you travel down here? Are you on the road all the time?
Well, when I was the chief, I traveled more, but we have an amazing system that was set up right from the outset, long before the pandemic, for video communication. So we can do meetings through that, and I don't have to travel. But I mean, I was coming down like average at least once a month. This particular month, October, this is my second trip, and I'm going to be down again next week. We have oral argument. So
Yeah, because we see you at various political functions sometimes, and yeah, you're down here often.
I try to make it to as many functions as I can. I mean, tomorrow night, for example, there's a senior law program awards dinner, so I like to go to that and the pro bono functions. And last week I was at the Inn of Court, so they had law students there. So yeah, if I can work it in, I try to do it. But I come down for court business, and then if there's something else, I'll do that too.
What was the most rewarding case you've seen in your career?
Wow. Well, I've handled thousands of cases in my whole career. You're
The most
talking
rewarding
about
one, the one that just stands out.
prosecutor or the judge or appellate judge. And I get asked that question, and the reverse question, of course, what's like the worst case? And it's hard to specify a rewarding case because court cases are almost always conflict. And it's rewarding that we can resolve the conflict and people can move on with their lives. If we just talk about a general class of cases, that when I was in the district court, I just general jurisdiction, so I did everything, and that included juvenile delinquency and juvenile dependency. Dependency is child protection, abuse and neglect. So those cases were the ones where you would try to put a family back together after a child had been removed. Or in some situations, it can't happen. But typically, you could do things for the parent to help them get their life on track and then get their kids back. And to see families reunified was always very rewarding, and that was the likely outcome in most of those cases. And I felt great about that. On a more personal level, adoptions were a lot of fun, and I did adoptions for a few people that I knew, including my law clerk at the time, and had adoptions where multiple kids being adopted at one time. I mean, those are really rewarding to see these kids are probably going to have a happy life with parents that really want them. So that's the other side of the coin in the abuse and neglect cases.
Mm-hmm.
The other types of cases, I'm sure you want to know about the tough ones.
Tough ones, yeah.
Yeah. There's so many of them that I've had. I've been giving that some thought. I expected you probably would ask me about that. And I mentioned two cases that were really tough. One as a judge and one as a prosecutor.
Okay.
So I'll go back farther in time and start with the prosecutor one. So I was the chief criminal deputy, so I was like the lead prosecutor in our office, and we had a sexual assault where an 18-year-old woman got out of her car in her garage, and a person came up from behind her and knocked her down to the ground, and then he was trying to rip her clothes off, and she was resisting, and he took her head and pounded it into the concrete floor of the garage and essentially knocked her senseless, and then proceeded to rape her. And I mean that, and of course she was hospitalized. She turned out she was okay, but it was really brutal.
Did they catch him?
Well, he was eventually caught. Not too long later. Well, there was another attack in the nearby vicinity a few nights later.
Same guy?
This same guy broke into somebody's house, went into a woman's bedroom, and she was asleep in bed, and he came in. And he attacked her and grabbed her by the hair and was banging her head against the post on the bed. And she had her 4-year-old son in bed next to her.
Oh, no.
Fortunately, she had a roommate, and she started screaming. So the roommate came out, and this guy ran out of the house. He had a mask on. So at any rate, a person was caught later, and it turns out he was 15 years old. He was almost 16, and he was caught with a stolen bike. And that led to the police to focus, the sheriff's office there to focus the investigation on him. He was eventually certified as an adult, but the part that went with it is he got bail, and he took off on his bail, disappeared, and wasn't found for several years. Well, this was one of the first cases where DNA evidence was used. So the DNA evidence that was originally had was pretty good. But when he was caught years later, we had the DNA reanalyzed using the newer techniques, and it went from like, maybe 1 in 100,000 to 1 in 100 million, so we know it's the right guy. So anyway, he was brought back from Florida. He was prosecuted, and he ended up pleading guilty to multiple charges. And the victims in that case, like I said, they recovered, but nonetheless they're traumatized for life. And that case led me to go to the legislature to seek a change in the law on victims' rights about what victims could say to a court at the sentencing hearing, because the person, even though he pled guilty, he still appealed. And he was challenging some of the victim statements, and I actually got a bill through the legislature that changed that.
Good for you.
And yeah, and that law has stood the test of time. We had a case on that law a couple of years ago, and then the Supreme Court took it, and it was upheld. So at any rate, that was one of the more difficult cases, because actually the second victim, I knew her before ahead of time, and the first victim, she was just really messed up for a while, but to see them recover and there was justice done, and as I mentioned, you can get the law change coming out of that. The second case is a case I had as a district judge, and I mentioned was general jurisdiction, so I did family law in the district court. And I had a custody case where I gave the father custody. I thought that he could better serve the needs of the children, and of course the mother was not very happy about it. And sometime later, quite a bit later, her new boyfriend went to the father's house at 3 o'clock in the morning with a shotgun, broke in, went into the bedroom. He's in bed with his new wife, and he shot him in the head, literally blew his head off. And I mean, that is like as horrifying as you can imagine.
What's the purpose of that?
Wow. Yeah, he goes to prison, the kids lose their dad, and
That's it, lost their dad.
wow.
And I felt bad because I was the one that gave custody to that, and I know that wasn't it, but it did start a chain of events, so that was really disconcerting for me. Well, somehow this case caught the attention of the national media, and NBC Dateline did a show on it called While They Slept. You can look that up on their website. And so I still get people calling me about that show. They see it on TV. Because I had the criminal case then, too, with the guy that did the shooting. The wife, the ex-wife, was in prison for something else. She was named as a co-conspirator, but she was never charged for reasons I don't know why. So anyway, this case came in front of me for sentencing, and the plea agreement said to give this guy life with the possibility of parole.
Right.
And the surviving wife of the man that was killed testified, and other family members, and I was horrified, and I said, I'm not going to follow this plea agreement. You're getting life without parole. And I mean, saying that, even though I felt strongly about it, is still hard, because life without parole means life without parole. The only way to get out of that is with a pardon. But I thought that was the just and right thing to do in that circumstance, because he destroyed multiple lives.
So he's still in prison.
Oh yeah.
What happened to the kids? Where did they go?
Well, there was that was stepmom that's still alive. Of course, the natural mom was in prison, so they weren't going to them. So there's always a question about who's going to get custody. Eventually, the stepmother ended up with custody. Although I did not make that decision. So that was in another case. But just a couple like horrifying cases, but good things can occasionally come out of them. It's hard to think of a good thing in a case like this one, but it's a learning lesson that when people are in court, for me, when I'm going to rule against them, I always try to say something positive to them, even if they're going to prison, unless they are just totally lost to society and there's no hope. Because you want people, back to your original question, to have faith in the court system, that they're listened to, their concerns are heard, and even if they don't get what they want, at least they know they had a shot at it, they had a fair hearing. So I try to always tried to convey that as a district judge with everybody I dealt with. On our court, it's in writing, and we're not talking to the people. We only issue written decisions, so it's much harder to do it, but we have to speak through our written words.
Do you ever get death threats from people?
I've never had a death threat. I've had some indirect threats. One of the first family law cases I did when I got on the bench, I gave custody to the mother, and the father said that if anything ever happens to his kids, that he was going to hold me responsible. And fortunately, nothing ever happened. I had another person I had sent to prison for burglary. It was the county manager's son. He burglarized homes where there had been a fire in the area and people had to evacuate, and then went into homes. And I said, this is just not the kind of case for probation. You're going to prison. I don't care who your dad is. And while he was in prison, he escaped, and he called the Douglas County Sheriff's Office and told them he was coming our way and he wanted to talk to me. So,
Yeah, sure he did.
fortunately, I never saw him, and they eventually found him very quickly. So I've never had a direct death threat, but
Wow.
2 indirect threats. I know there are other judges been threatened. Of course, I knew Judge Weller in Reno, who got shot in his chambers.
I remember that.
So I mean, it is a
Mac.
real concern.
Mac. Darren Mac. Right?
Yeah, right.
So how do you decompress? Break a bottle of
Yeah,
scotch
what do you do
out?
outside the courtroom?
Go for a run? What do you do? Stretch? Do your yoga?
It can be a pretty stressful job. Actually, you're right on. I mean, exercise is a really good way to decompress.
Absolutely.
Something that I became involved in 25 years ago was soccer. I became a soccer coach for my youngest daughter. I have 3 daughters, and my middle daughter played soccer, but I was so busy in the district attorney's office, I was only able to be somewhat involved. But when I became a judge, I could set my own schedule. So I said, all right, I'm going to coach. I don't want to miss this with my youngest daughter. So I coached for 12 years, all kinds of teams, all age levels. And that was really a stress reliever, a different kind of stress, game, but that helped a lot. But exercise was it. I've tried to eat really well. I've been having a smoothie for breakfast for the last 40 years. It's full
40
of
years.
40 years. It's full of all sorts of healthy stuff. And when I travel, I take it with me. I'm going to have it tomorrow morning, even though I'm staying in a hotel. So good eating and exercise, and of course you have to have good emotional and mental health too. Everybody has stresses in their life. You got to talk it out with other people. And of course, I'm married. I have a great wife, and she's very calm, so that helps a lot too.
Any grandbabies?
I have 3. My oldest daughter has 3 boys, so yeah, I have 3 grandsons. They're all great kids too. My other 2 don't have any kids, but I've seen so many kids from adoptions, custody cases, through the CASA program. I've been around kids a lot, and in fact, I even went to Holland and coached in a soccer team there on a program called People to People. You might want to look it up sometime. It's to promote athletic and educational development of young people in the U.S. and involved with international. And so we went to a soccer tournament in Holland, and I got to coach there with kids I didn't even know. They came from all over the United States, and our team was put together there. We were in a tournament against teams like from Brazil and England, and we didn't do so well. We won 1 game out of 8, but nonetheless, the kids had a great time, and it was a very fun and educational experience. So doing stuff with kids is what I tried to do.
Speaking of mental health, should judges undergo psych evaluations before they take the bench, or even throughout their? Well, we've talked about this before. I've asked many judges this. Even throughout their term, or reevaluate if they're reelected, or what? Do you think that, because we've seen some crazy judges?
Well, I think that, I mean, there was some proposal in the legislature like that. I forget exactly what it was supposed to do, but it was something like that, and it didn't pass. No, I wouldn't support that. I mean, we need more judges, not less, and that'll scare a lot of people away.
You think
Maybe
so?
for good reason, though.
When you go through a appointment process, they look at those things.
Yeah, I told you we had to
Yeah.
do a release on everything.
Yeah.
Everything.
So why can't an elected be the same way?
Well, the methodology is to make the complaint if somebody looks like they're not having a clear moment. And by the way, as part of continuing legal education, we do have to take courses related to that, substance abuse, mental health.
Right.
In fact, I was at a conference last week, and we had a presentation on stress, just what you were talking about. So that's required. We have to do that. Yes, the legal profession is extremely stressful. There's a high incidence of substance abuse, unfortunately, and that's there's a Lawyers for Lawyers organization to help people in that situation and other things, and it needs to be reported. And that was one of the points of emphasis last week is, hey, you can't let this stuff go by. You have to report it because it affects the people involved and the profession as a whole.
Right.
So I think there are alternative means. Of course, there are occasionally going to be a bad apple here and there, but fortunately we don't have that very often in Nevada, at least not that I've seen anyway. But what about any other profession?
Right.
I mean, we get lots of cases on appeal against doctors for malpractice, even for lawyers for malpractice. I mean, there are mechanisms to deal with it.
You know, you brought up that shotgun case, and I had one of our viewers wanted to know why wasn't the death penalty on the table, or was it?
Well, I was the judge on it. I wasn't the prosecutor, so
They didn't ask for it.
It might. Well, when it was presented to me, it was in a plea agreement. So I don't recall them ever asking for it, but the plea agreement only allowed for life with parole or life without parole. And the agreement was to recommend life with, and as I mentioned, I gave life without, but the death penalty was not on the table at that point in time. If it had been, then there would have to have been a jury deciding. A judge can't decide it.
You're a prosecutor.
Right?
In that type of case, would you have asked for the death penalty?
There's a reasonable chance. I mean, the death penalty is a whole long conversation itself, and I actually got asked about the death penalty in the Judicial Selection Commission. I had a number of cases where I filed for the death penalty as a prosecutor, and in every one of those cases, the person ended up pleading guilty to avoid that possibility. The case where I didn't ask for it, it went to a jury trial.
Right.
So you can see the difference.
Yeah.
I did a case as the district judge for another jurisdiction. In other words, the person had gotten the death penalty maybe 16 years before,
Right.
and he'd been through multiple appeals in federal court multiple times, and the judges were long gone. They couldn't hear the case anymore, so I got assigned this case, and that was in the late 90s. This person was 18 when he committed a triple murder,
Yeah.
and do you know where he is right now?
Where?
Still in the Ely State Prison from a crime from 1980, and he got the death penalty. So
Wow.
that tells you something there about the effectiveness of it.
Okay. Ms. Phillips, do you have anything else?
That's it.
I was going to say Justice Gibbons. Judge Gibbons, thank you for coming on the program. Oh, sorry. Could you look into the camera and, you get the last word.
Well, this is the Veterans in Politics show, and I have a lot of respect for veterans. I never served myself. However, in my family, both my parents were in the Navy during World War II. My wife's father was in the Navy in World War II. Her brother was in the Naval Reserve long enough to get a full retirement. And my former son-in-law served in the Army for 12 years. He was in combat in Iraq, and then he later went into Special Forces, so he served in a lot of places. So I know what people go through, and it's a life-changing event to be in the military, particularly in armed conflicts like that. and we need to do everything we can to help our veterans, particularly in the court system. And I've had some tough cases that involve veterans, and I've always kept that in mind, that what these people went through, the service they gave, and that has to be factored into any decision that's rendered. So I thank all of you for your service, and you have to know that people really appreciate you putting your life on the line. And did you serve in the Marines?
Marines and Army.
Marines and Army. Oh, okay. You served?
My son
Okay.
is in the Army.
All right. Well, that says a lot right there. It's not it's a very tough career to take on. So thank you again for your service.
Well, I want to thank you, Judge Michael Gibbons, for coming on the program. I really appreciate you. And sorry about the little technical difficulties we've been having today.
We lost a little bit of time. How much? We got most of it.
We're good.
Yeah.
Thank you, Ms. Phillips. And folks, that's Michael Gibbons, Nevada Appellate Court Judge. And we don't have our sound or cameraman today, so don't be alarmed when Ms. Phillips
Oh,
gets...
no, you're going to have to go turn it off.
when I get up to turn off the camera. And you know what? This is good. This is good. This is absolutely good, because this is going to tell us that we need to do different things to make sure that if something goes short, we have a backup.
Well, we need to figure out how to run these little microphone, the volume, and we need one of those remotes. that
And we'll get it
operates
done. We're going to be so
I-
technically savvy, it's going to make your head spin. But this is Steve Sanson and Stephanie Phillips with Veterans in Politics. Until next time.